Hello and welcome to today's program. My name is Jim Sobere. I'm the president of Brinks Gilson Lione. It's our pleasure to have you join us today. Today we're going to look at some important changes that occurred in 2013 and how they may continue to have impacts on intellectual property law going forward this year, as well as discussing future changes that we anticipate will occur during the course of this year. At Brinks, it's our mission to help our clients achieve their legal and business objectives regarding their intellectual property issues. We help clients with comprehensive IP strategies tailored to their individual needs. We help clients identify their IP assets, procure IP protection, manage their IP portfolios, and enforce and defend IP assets. We have a deep roster of IP experts in all aspects of IP law and in every field of technology and science. In total, we have over 160 attorneys and scientific advisors and patent agents across 7 offices in the U.S. We're headquartered here in Chicago. We also have 2 offices on the East Coast in Washington, D.C. and Research Triangle Park, North Carolina. We have an office out west in Salt Lake City, Utah. And we have a strong core in the Midwest with our Chicago office, as well as 2 offices in Michigan, in Detroit, in the same building where the U.S. Patent Office has a satellite office, and also a big practice group in Ann Arbor, Michigan. And we also have an office in Indianapolis, Indiana as well. So we're well positioned to serve our clients across the country. We also are fortunate to be continued to be recognized by leading independent publishers who rate law firms. We continue to receive high marks in all aspects of intellectual property practice. Now let's talk about today's program. We have 4 presenters here today, 4 of my partners who are just stellar IP lawyers in patents and trademarks and various aspects of these practice areas. They're Brad Lane, Amir Penn, Mark Richards, and Scott Slavic. We're going to start today with Scott. He's going to review some top trademark decisions from 2013 and talk about what continuing impacts they may have this year. Then Mark Richards and Amir Penn are going to discuss patentable subject matter in both the life sciences and software industries. Then Brad Lane will wrap up and give us an overview of important features of some pending legislation regarding patent reform. Again, thanks for joining us today. It's now my privilege to turn the program over to Scott Slavic.
Courts across the country have been busy dealing with some high-profile trademark disputes this past year. I've picked the most potentially influential cases to discuss with you today. First, let's start with the United States Supreme Court's only pure trademark holding of 2013, Already versus Nike. In it, the Supreme Court affirmed the Second Circuit's decision ruling that infringement plaintiff Nike's covenant not to enforce its registered Air Force One product configuration trademark against Already's shoes and any future similarly designed shoes rendered moot Already's counterclaim for a declaration of invalidity of Nike's product configuration trademark. Nike brought its trademark infringement suit in the Southern District of New York, alleging that Already's Soulja Boys and Sugar shoes infringed and diluted Nike's Air Force One product configuration trademark, and demanding that Already terminate the sale of those shoes. Already filed a counterclaim contending that Nike's Air Force One product configuration trademark was invalid. 8 months after Nike filed its complaint, and 4 months after the counterclaim, Nike issued a covenant not to sue. The covenant promised that Nike would not bring any trademark or unfair competition claims against Already based on any of Already's existing shoes or any of Already's future shoes that constituted colorable imitations of Already's current shoes. Nike then moved to dismiss its claims with prejudice and to dismiss Already's counterclaim without prejudice on the ground that the covenant had extinguished the case or controversy. Already opposed, arguing that Nike had not established that Already's voluntary cessation had mooted the case. The district court dismissed Already's counterclaim and the Second Circuit affirmed. The Supreme Court framed the question presented as follows: whether a covenant not to enforce a trademark against a competitor's existing products and any future colorable imitations of those products moots the competitor's action to have the trademark declared invalid. The Supreme Court ruled that the breadth of Nike's covenant not to sue was sufficient to meet the burden imposed by the voluntary cessation test. Nike's covenant was unconditional and irrevocable. Beyond simply prohibiting Nike from filing suit, the covenant prohibited Nike from making any claim or any demand. It reached beyond Already to protect Already's distributors and customers, and it covered not just current or previous designs, but any colorable imitations. Given the covenant's broad language, and given that Already had asserted no plans to produce similar shoes, the Supreme Court concluded that the case was moot because the challenged conduct could not be reasonably expected to reoccur. This case provides further clarification that the voluntary cessation doctrine is alive and well, and that a party claiming that its change of conduct has mooted a case will bear a heavy burden. In the intellectual property context, the case makes clear that a properly written covenant not to sue remains a viable option to end a declaratory judgment lawsuit. While this situation arises relatively rarely, the ability to terminate a lawsuit rather than face ongoing litigation expenses or a uniquely bad outcome may be a useful tool for IP owners managing broad portfolios or enforcement programs to consider. Nike's covenant not to sue, blessed by the Supreme Court, will likely become the gold standard against which courts will scrutinize further covenants. Such covenants not to sue are more likely to survive judicial scrutiny where they are 1. Irrevocable and unconditional, 2. Apply to all demands, not just lawsuits, 3. Protect downstream customers, and 4. Cover not just past and present conduct, but future infringement as well. Intellectual property owners should carefully consider the broader implications of such covenants and should bear in mind the potential risks and consequences to their IP rights. We've all heard of reverse domain name hijacking, but can you reverse domain name hijack a top-level domain name? That was the question in the Del Monte case. A top-level domain is everything to the right of the dot in an internet domain name. For example, the .com in brinksgilson.com. Last year, ICANN accepted applications to register new generic top-level domains, also known as GTLDs. Only now some will not be so generic. In addition to the GTLDs with which we're all familiar, .com, .net, .org, the newly available GTLDs include brand names such as .Brinks Gilson, geographic identifiers such as .nyc, and industry identifiers such as .beauty or .basketball. ICANN provided trademark owners until March 13, 2013 to file formal legal rights objections to any GTLD application. Under this procedure, a panel of neutrals determines whether the applicant's potential use of the applied for GTLD would be likely to infringe the objector's existing trademark rights. If a legal rights objection is granted, ICANN will not issue the applied for GTLD. DM Corporation owns the Del Monte trademark. DM International is one of DM Corporation's licensees. DM International, not DM Corporation, applied to register the GTLD .Del Monte without DM Corporation's permission. DM Corporation immediately filed a legal rights objection to DM International's application. The expert panel upheld DM Corporation's legal rights objection and rejected DM International's application. In granting the objection, the panel questioned whether DM International had any bona fide rights in the Del Monte mark and determined that the applied for .Del Monte GTLD would be likely to create a likelihood of confusion between the GTLD and DM Corporation's Del Monte trademark. Undaunted, DM International then filed a complaint for declaratory relief in the Central District of California against DM Corporation, claiming that the panel's decision was manifestly erroneous and requesting declaratory relief from the court, namely a declaration stating that 1. DM International had bona fide rights in the Del Monte mark, 2. It's not a violation of the Anti-Cyber Squatting Consumer Protection Act, 3. that the registration of the Del Monte GTLD would not create confusion, and 4, ordering DM Corporation to withdraw its legal rights objection. In its arguments, DM International stated that what DM Corporation had done by objecting to the .Del Monte application was reverse domain name hijacking, because DM Corporation didn't apply for the .Del Monte GTLD itself, and only after DM International did DM Corporation become interested in the GTLD. The legal rights objection decision and the subsequent declaratory judgment complaint filed by DM International suggests that there may be more to the parties' relationship than first meets the eye. However, as trademark law dictates that a licensee's use of a trademark should inure to the benefit of the licensor, if DM International is truly a licensee of DM Corporation, it will be interesting to see whether the court ultimately finds that DM International has any rights to operate the GTLD without permission from DM Corporation. Regardless of the outcome, this is a case that all brand owners should follow with interest, as it may prove valuable in learning what treatment district courts will give the new GTLDs in the context of intellectual property and other rights. Near the end of 2013, the Supreme Court heard oral arguments in Lexmark versus Static Control Components and is yet to issue its decision. This case is very interesting because the Supreme Court's decision could go a long way towards clarifying who can sue for false advertising claims under the Lanham Act, a question that has baffled courts around the country for years. This long-running, since 2002, and complex case involves the toner cartridge market. Lexmark sells toner cartridges designed for a single use, controlled by a microchip inside the cartridge. Static Control sells replacement microchips to cartridge remanufacturers that allow Lexmark cartridges to be reused, in conflict with Lexmark's one-time-only intent. Although the parties don't directly compete, Lexmark sells cartridges to consumers and Static Control sells microchips to remanufacturers. Static Control can sell its replacement microchips only if reusing the Lexmark cartridges is legal. And if Static Control can enter the replacement microchip market, the competition from remanufactured cartridges will undoubtedly reduce Lexmark's sales of new toner cartridges. In response, Lexmark made several public announcements that remanufacturing cartridges would violate Lexmark's legal rights and pursued a number of litigations. Static Control won an important copyright ruling in 2004, allowing it to sell its replacement microchips. The parties are now fighting over some of Lexmark's allegedly false statements made to remanufacturers about the legitimacy of Static Control's microchips. A vast array of federal and state laws regulate false advertising, including the Lanham Act. The Lanham Act limits who can sue for violations, but federal appellate courts around the country have adopted differing tests for determining Lanham Act standing. The Supreme Court's opinion in this case will hopefully choose one test for all courts to follow. It has several standing tests to choose from, including 1, the Associated General Contractors of California cases test, which uses multiple factors to determine a party's standing, including how easy it would be to allocate damages among the parties, and overall is fairly restrictive concerning standing. It's employed by the 3rd, 5th, 8th, and 11th circuits. The second test is the categorical test, permitting suits only by an actual competitor. It's the most restrictive standing test, and it's employed by the 7th, 9th, and 10th circuits. The third test is the reasonable interest test, which takes a more expansive approach to who might suffer competitive injury, making it the most permissive on standing, and it's employed by the 6th and 2nd circuits. In an interesting twist, the Associated General Contractors of California case's opinion was written by now Justice Alito, so the Associated General Contractors of California case's test may already have one supporter on the court. Of the 3 tests, the reasonable interest test is the most plaintiff favorable, and the categorical test is the most defense favorable. Static Control actually bypassed all 3 of these potential tests and advocated its own test, a test evaluating if the plaintiff is in a competitive zone of interest with the defendant, perhaps an even murkier standard than the reasonable interest test. Given the anarchy in the briefs, this case could easily go sideways at the Supreme Court. The court could decline to adopt a single standing test, or it could issue a fractured set of opinions without a clear consensus. Or the court could adopt a single standard but articulate the standard in a confusing way. Or the court could articulate a clear standing test but apply it to the facts in a way that leaves everyone confused. Unfortunately, I'm not sure this case presents an ideal set of facts to elicit a clear Supreme Court ruling. The underlying competitive issues that I discussed before between Lexmark and static control are somewhat hard to grasp and aren't really representative of the Lanham Act standing problems we typically see. Depending on what the Supreme Court decides, this ruling could have substantial implications for not only competition in the printer-toner cartridge market, but it could significantly affect how new entrants use false advertising litigation to crack open what is considered a closed market. Even if the Supreme Court adopts the narrowest interpretation of standing, Lanham Act false advertising is just one of many overlapping regulatory doctrines applicable to false commercial statements. The Federal Trade Commission, state attorney generals, consumer private class action lawyers, public interest groups, and competitors have multiple ways to combat falsity in the marketplace. So no matter how the Supreme Court rules, I expect false advertising litigation will remain busy. There were 3 other cases that I just wanted to mention that are also worth noting. First, in 1-800-CONTACTS versus Lens.com, the 10th Circuit held that purchasing keywords for sponsored links on internet search engines that contain registered trademarks of competitors does not alone amount to trademark infringement under the Lanham Act. This decision ratifies what is now a common business practice in internet marketing and should make internet advertisers feel slightly more comfortable about buying competitors' trademarks in order to drive traffic to their own websites. Next, we may have finally received the final decision in what seems like the never-ending Starbucks versus Wolfsboro coffee case, otherwise known as the Charbucks litigation. The Second Circuit concluded that Starbucks failed to prove that the defendant's use of the marks Mr. Charbucks and Charbucks Blend was likely to dilute the famous Starbucks mark. This decision significantly adds to trademark dilution jurisprudence. Finally, in Kelly Brown versus Winfrey, the Second Circuit split from the Sixth Circuit over whether a trademark plaintiff should be required to prove that a trademark defendant is using the complained of term as a trademark to state a valid trademark infringement claim. If left unresolved, we may have just found the Supreme Court's next trademark case. As you can see, the trademark cases of 2013 will have a major impact on not only 2014 trademark law, but the years to come.
Thank you, Scott. Our next presenters are Mark Richards and Amir Penn, who will discuss patentable subject matter in both the biotech and software industries. Mark, please start us off.
Okay, thank you, Jim. One area where patents are increasingly being challenged as courts is the patent eligibility standard under 35 U.S.C. Section 101. So today, we are going to look at the legal background for patent eligibility and see how the standard seems to be changing in some recent cases that have been decided both in the life sciences area as well as computer-related inventions. We also try to provide some tips on how to protect your inventions in this uncertain era. To obtain a patent, U.S. patent laws require that an invention be useful, new, and non-obvious. In addition, the invention has to fall within one of 4 statutory categories to be eligible for a patent. And those categories are a process, a machine, a manufactured item, or a composition of matter. The Supreme Court reminded us in its recent Bilski decision that these statutory categories were designed to encompass new and unforeseen inventions in the future. In Bilski, the Supreme Court held that there was no ban on patenting business methods per se, provided that the invention did not fall within one of the judicially created exceptions to patent eligibility. These exceptions are products of nature, or naturally occurring products, natural phenomena, or laws of nature, and abstract ideas. It is these judicially created exceptions to patent eligibility where the courts are rethinking where the boundaries lay between eligible and ineligible subject matter. So although courts have been grappling with this issue for over 100 years, as far back as when Samuel Morse invented the telegraph and Morse code, it's helpful to look at some recent cases in the 1970s and 1980s that provide the guidance for the court's decisions today. In the first of one of three seminal cases involving computer-related inventions, in Gottschalk v. Benson, the Supreme Court held that an invention directed to a mathematical algorithm used by a computer processor to convert data into binary code was not patent eligible. The court held that you could not patent a method for using an algorithm in a computer where the patent would preempt all practical use of that mathematical algorithm. The court stated that mental processes and abstract intellectual concepts are not patentable, as they are the basic tools of scientific and technological work. In the second of these cases, dealing with computer-related inventions, the Supreme Court in Parker v. Fluke held that a method for setting an alarm in a computer for use in a catalytic conversion process was not patent eligible. As in the Benson decision, the court determined that the claimed invention was directed to a mathematical formula, which was an abstract idea, one of the judicial exceptions to patent eligibility. The court reasoned that merely limiting the use of a mathematical formula to a technological environment does not make the patent or the formula patent eligible. In the 1980s, the Supreme Court heard two more cases involving patent eligibility, and this time came out on a more positive note. In Diamond v. Chakrabarty, the Supreme Court held that an invention directed to bacteria that was genetically modified to be able to eat oil is patent eligible. The court found that this bacteria was man-made. It was not naturally occurring and not found in nature. Therefore, it did not fall within one of these three judicial exceptions. Indeed, a very positive note, the court stated that anything under the sun that is made by man could be patent eligible. In the following year, in Diamond v. Deere, the Supreme Court held that an invention directed to a method for curing rubber that involved the use of a mathematical formula was patent eligible. In this case, the court noted that the invention was directed to transforming physical material to a different state, and it was not merely directed to a computer applying the mathematical formula. Therefore, by incorporating the abstract mathematical formula into a known physical process, the invention was deemed to be patent eligible. So with that background, let's turn to some of the recent cases where this issue on patent eligibility has been decided for some life science inventions. In Mayo Collaborative Services versus Prometheus Labs, the Supreme Court held that a method for treatment of certain gastrointestinal diseases, such as Crohn's disease and ulcerative colitis, was not patent eligible. The court noted that the scientists' real discovery here was the precise measured levels of drugs in the patient for optimum treatment. In the claimed invention, this method required administering the drug to a patient, determining the level of the drug in the patient. And if the measured level was too low, it indicated a need to increase the amount of drug. If the measured level was too high, it indicated a need to decrease the amount of drug given to the patient. The Supreme Court held that these claims were not patent eligible because they were directed to a natural phenomena. the relationship between the dosage level and the optimal effectiveness of the drug. The court noted that any scientist that would want to take advantage of this natural phenomena would have to carry out the routine and conventional steps of administering the drug and determining the level of the drug in the patient, which were mere routine conventional activity previously engaged by scientists who worked in this field. In effect, this claim would preempt all use of the natural phenomena, and in effect could not be protected by a patent. So what is particularly unsettling about this decision is that the Supreme Court seemed to conflate the analysis of patent eligibility with the analysis for novelty and non-obviousness. The court seems to have contradicted its earlier holding in Diamond v. Deere, and now has stated that as to the judicial exceptions to patent eligibility of applying laws of nature and natural phenomena and abstract ideas in conventional and well-known processes, this does not make such an invention patent eligible. As a result, in 2014, we may see many more patent lawsuits where the parties are fighting as a threshold question over the patent eligibility of the inventions, where many previously thought such questions did not exist. In another Supreme Court case, Association for Molecular Pathology versus Myriad Genetics, the parties were fighting over whether or not claims to DNA were patent eligible. In the Myriad Genetics case, the Supreme Court held that patent claims to isolated DNA were not patent eligible. This came as a surprise to many because the U.S. Patent and Trademark Office has been granting such patents on such inventions for the past 20 years. Here, the scientists at Myriad had discovered the location and sequence of mutations in the BRCA1 and BRCA2 genes that are associated with increased risks of breast and ovarian cancer. So the patents at issue in this case were directed to isolated DNA, isolated cDNA, which is also known as complementary DNA. As you can see from this chart, in the upper left, a gene can be extracted from a cell and then isolated and purified. This DNA is not found in nature in this isolated and purified form. Then to create cDNA, the DNA must undergo many steps to remove the introns or inactive portions of the gene. Then the active portions, which code for proteins known as exons, are spliced back together. Then further processing steps are required to ultimately create the cDNA. So the claims at issue in the Myriad, in this case, were directed to isolated DNA, isolated cDNA, and fragments of both the DNA and the cDNA. As to the claims directed to the isolated DNA, the Supreme Court noted that Myriad did not really create anything here. All they did was found an important and useful gene and separated that gene from its surrounding genetic material, which is not an active invention. The court noted that these exceptions to patent-eligible subject matter are important because they ensure that the basic tools of scientific and technological work lie beyond the domain of patent protection. The court here found that naturally occurring DNA segments are just a product of nature, and even if isolated, could not be eligible for patent. But cDNA is patent eligible because it is not naturally occurring. Although the holding of this case is limited to claims directed to DNA, it opens the door to questioning the patent eligibility of any material that coincidentally might be identical to what is found in nature. There are still more lawsuits pending involving Myriad Genetics that have yet to be decided. So 2014 may yet bring some additional surprises as what may be patent eligible subject matter for the biotech industry. So when it comes to protecting your inventions in the life sciences, one has to take these cases into account and move beyond claiming just merely isolated DNA or other isolated products found in nature. It's important to draft a variety of claims of different scope and different subject matter beyond the natural products. Should try to claim practical applications of these natural products or dosage regimes. For example, compositions and formulations comprising these natural products and or its derivatives may be claimed. Also, methods may be claimed using these natural products with an eye towards the end commercial products and services to be provided. So and now Amir Penn will continue the discussion and talk about how courts are dealing with this issue for patent eligibility of computer-related inventions.
Thank you, Mark. We will focus on two recent decisions directed to patent eligibility of computer-related inventions. The first is CLS Bank versus Alice Corp. And in that case, the patent was directed to computerized trading in an effort to eliminate the risk to the counterparty. Of note, the claims were directed to the method, the computer system, and the computer-readable medium. Procedurally, at the district court level, all claims, method, system, and computer-readable medium claims were found not directed to patent-eligible subject matter. And the initial appeal before the three-judge panel found that the claims were directed to patent-eligible subject matter and reversed the lower court. Because there is so much ambiguity as to the standard of patent eligibility for computer-related claims, the decision was vacated and the case was taken for en banc rehearing.
We examined one patent claim in Alice Corp., the system claim, which recites a data storage unit, basically a memory, and a computer that's configured to perform certain actions, including electronically adjusting the shadow credit record, a part of the memory, as well as generating an instruction to an exchange institution. So on its face, the system claim recites hardware elements as well as the interaction within those hardware elements. The Federal Circuit en banc held that the Alice Corp. Method and computer-readable medium claims were not patent eligible. The en banc court split 5-5 as to whether the Alice Corp. System claims were patent eligible, and in total, there were 5 conflicting opinions. We examined one of those opinions, Judge Lurie's, which recited several factors, and it's boiled down to basically a 2-part test. The first of which is, does the claim subject matter fall within a statutory category? Process, machine, manufacturer, composition. This first part is a fairly low burden to overcome. The second part of the test is, does the claimed invention broadly fall within and preempt a judicial exception? For example, law of nature, natural phenomena, or abstract idea. And more specifically, does the claim include substantial limitations that, in practical terms, won't foreclose using this abstract idea? And of note, these substantial limitations must include the inventive concept and not merely some human contribution that's considered trivial. Again, the 5 conflicting opinions in the en banc decision reflect the uncertainty as to the standard of patent eligibility. And because of this, the Supreme Court has granted cert in this case. The question presented for Supreme Court review is a very basic one, namely, whether claims directed to computer-implemented inventions are directed to patent-eligible subject matter within the meaning of Section 101. We focus on another recent Federal Circuit case, Ultramershal versus Hulu, which is directed to the sale of copyrighted media over the internet. We examined one claim in the Ultramershal case, and there are 2 things to note. The first is that it is a method claim, and the second is the number of limitations within the claim. For editing purposes, I haven't included the entire claim, but there are 11 steps in total to this method claim. The 3-judge panel before the Federal Circuit held that the Ultramershal method claims were patent eligible. And Judge Lurie applied his test and said that the ultra-commercial method claims, being method, were directed to a process, one of the statutory categories of patent-eligible subject matter. And Judge Lurie had said that the claims were not directed to a patent-ineligible abstract idea. And his reasoning was that all of the limitations, those 11 limitations within the method claim, represented significantly more than merely an abstract idea, in this instance, using advertising as an exchange or currency. A few additional thoughts on patent eligibility for computer-related matter. This goes without saying, but the standard for patent eligibility is far from being resolved. There is really no clear guidance as to draw the line, what is patent eligible and what is not. Different CAFC judges take different approaches, so the outcome of a Federal Circuit decision will be based in part on which judges are on your panel. There is a general consensus, however, that if the subject matter is not technological, for example, business method claims, then the claim should add meaningful limitations so that the abstract idea is not preempted. The question then becomes, will the Supreme Court, in reviewing the CLS Bank case, provide greater clarity on the standard for patent eligibility? In all likelihood, the answer is no. The Supreme Court typically avoids bright line rules regarding patent eligibility. So the question becomes, what are some recommended tips with regard to both drafting applications as well as prosecuting applications to computer-related matter? With regard to drafting applications, it's important to include as much computer hardware in the patent specification as practical. Try and tie your invention to as many pieces of hardware, memory, processor, communication aspects. Also include detailed flowcharts of the process and include a description of the technical effects of the invention. With regard to claiming, two things to note. The first is to prepare multiple claim sets directed to the different statutory categories: method claims, system claims, non-transitory computer-readable medium claims. And separate from that, prepare multiple independent claims of varying scope, both broad claims as well as narrow claims. So attempt to prepare generic claims trying to remove business method context, but focus on the content-neutral technical implementations. As well, prepare narrow or independent claims akin to ultramercial that stand on their own, include added meaningful limitations compared to broader independent claims. And with that, I'll turn the platform back to Jim.
Thank you, Amir. Thank you, Mark, for your very interesting and enlightening comments and overview. Our next presenter is Brad Lane. Brad is going to provide us with an overview and some insights on some pending patent litigation reform legislation.
Thank you, Jim. On December 5th, 2013, the United States House of Representatives passed the Innovation Act, that is H.R. 3309. This House bill has a wide range of provisions directed to litigating patents in the federal court system and the United States Patent and Trademark Office. Passage of this House bill was swift. It was introduced by House Judiciary Committee Chair Bob Goodlatte, and within 6 weeks, it was passed by the full House of Representatives. This House bill is based on the notion that non-practicing patent assertion entities, patent trolls, were taking advantage of current court procedures to conduct abusive patent litigation. The provisions of this bill do not define what a patent troll is, nor do they specifically target particular entities that seek to enforce their patents. Rather, the provisions are directed to what the House of Representatives considers abusive patent litigation practices in enforcing patents. Now, there is a Senate bill that's S-1720, recently introduced by Senator Patrick Leahy of Vermont and Mike Lee of Utah. This Senate bill is also aimed at curbing patent troll activities. This Senate bill has yet to leave the Senate Judiciary Committee and has not been presented to the full Senate for vote, but it's expected to be voted upon later this year in 2014. So it would be well for companies to consider the provisions of the recently passed House bill and the pending Senate bill to determine how these bills will affect litigating patents in the future if these provisions become law. One provision of H.R. 3309 is Section 3A, and it requires a great deal of disclosure of infringement allegations. Under current law, under Federal Rule of Civil Procedure 84, in conjunction with Form 18 of Federal Rule of Civil Procedure, it allows for very little disclosure of allegations of direct infringement. A complaint under current law is deemed acceptable if it just merely identifies the patent, it identifies a product vaguely that's accused of infringement, such as an electric motor, and identifies the infringer. This notice pleading has been deemed sufficient under current federal civil practice law for over 50 years. H.R. 3309 would eliminate this type of notice pleading. It would require identification of particular claims that are asserted to be infringed, to identify the accused device or process with particularity by model number or design version. Also, one must provide the contentions for each limitation that are allegedly infringed, and also identify a patent owner's business, all past complaints that have asserted the patent, and also any type of licensing or standard essential arrangements directed to the patent. The Senate bill, as it is currently proposed, does not have this heightened pleading requirement provision. One reason for this could be that under normal federal rulemaking procedures, the Committee on Rules of Practice and Procedure of the Federal Judicial Conference is holding hearings in January and February of this year to determine whether the current rules should be amended. So changes to the Federal Rules of Civil Procedure may result by the end of this year under normal rulemaking activities. Another provision of H.R. 3309 is Section 3B, and that is directed to changing the American rule as far as attorney's fees are concerned. The American rule currently is that each party bears its own attorney's fees. That rule is also under Section 285 of the patent statute, which also recognizes that each party bears its own attorney's fees unless a court deems the case an exceptional case. It's only when a case is deemed exceptional that the loser pays the winner's attorney's fees under current law. Section 3B would change this. Under the House bill, it's presumed that a losing party will pay an opponent's attorney's fees. The presumption of the losing party paying a winner's attorney's fees can only be avoided if either the losing party has shown that it was reasonably justified in law and fact, proceeding the way it did, or there are special circumstances that are provided in the provision to be such as severe economic hardship to a named inventor. Interestingly, the Senate bill, as currently proposed, does not have this provision as in the House bill. One reason could be that the standard of exceptional case is currently the subject of a Supreme Court case by the name of Octane Fitness versus Icon Health and Fitness. So the Supreme Court could provide guidance in this area under current law. In conjunction with the attorney fee provision of the House bill, there is also provided Section 3C, which identifies that an interested party could be joined to ensure that an attorney fee award is paid. Section 3C of the House bill provides for a presumption that an interested party, that is a party that's not originally a party to the lawsuit, must be joined by a court to pay for the attorney's fee award. All that needs to be shown is the losing party cannot pay the winning party's attorney's fees, and that the party that cannot pay this attorney fee award has no substantial interest in the litigation other than to assert the patent. The House bill goes into detail as to what an interested party is under these circumstances. An interested party can be an assignee or a party that has a right or contingent right to enforce or sublicense the patent, or a party has a direct financial interest in the patent, for example, has a part of the damages award or contemplated damages award. Again, interestingly, the Senate bill does not have this type of provision. Patent trolls can sometimes use the cost of discovery as a leverage point in making high demands for settlement. Potentially for this reason, Section 3D has been provided in the House bill. It provides for a presumption of limiting discovery in a case to just issues of claim construction. So under this provision, discovery for both parties would be limited to claim construction and no other issues. But this could come at a cost, the cost being that each party does not know the other party's contentions on all issues. There are exceptions to this limited discovery under the House bill for example, issues that are pending in a motion or for a preliminary injunction or for situations where the federal statute provides for a particular time period for decision, such as an abbreviated new drug application, that's an ANDA litigation in federal court, or a Section 337 investigation in the International Trade Commission. Again, the pending Senate bill does not have this provision. Another common troll behavior is to send vague demand letters to a party asking to negotiate a license or to settle a patent dispute, with just identifying the patents or a long list of patents and providing little information as to the basis for the demand. Later in litigation, a troll might use this letter as evidence of willful infringement, that the accused infringer knew about the patent but didn't do anything about it. House Bill Section 3F establishes that such vague letters that are demand letters cannot be used to show willful infringement. The House bill provides that demand letters can only be admissible in evidence if, for example, or if it identifies, that is, the letter identifies the patent, identifies the accused product or process, identifies the ultimate parent entity of the claimant, and explains how the accused product infringes the identified patents. The currently pending Senate bill goes further than the House bill on this subject. The Senate bill makes clear that it's an unfair and deceptive trade practice and therefore subject to Federal Trade Commission sanctions if a fraudulent or materially misleading demand letter is sent to another party. There have been reports that patent assertion entities or trolls use various corporate veils or partnership schemes to hide their true identity. Section 4 of the House bill is directed to such conduct. It requires that upon filing of a pleading, there must be disclosure to the United States Patent and Trademark Office, the court, and the adversary of the patent's true assignee, and a disclosure of all parties that have a right to sublicense the patent, and a disclosure of any entity with a financial interest in the patent, and disclosure of the ultimate parent entity for any of these entities that I just identified. Publicly held companies can easily comply with this disclosure by naming themselves, their business address, and the public exchange in which they are listed. Private companies, though, and venture capital groups and early capital investors may find that they are subject to much more onerous disclosure requirements under this House bill. Failure to disclose these interests will result in no attorney's fees being awarded and no willful infringement or other increased damages for the time period that the improper disclosure or non-disclosure occurs. This loss of right also travels with the patent to later owners. The pending Senate bill is a similar disclosure of interests in a patent provision, but it requires this type of disclosure within 3 months of an assignment. Although I'm focusing on legislation here, there's also possibly a more onerous provision that is recently promulgated by the United States Patent and Trademark Office rulemaking. On January 24, 2014, the USPTO issued a proposed rule to require identification of ownership information for patents and patent applications if there's a change in ownership or around the time of a patent application filing or at a time of the issue fee payment or a payment of a maintenance fee or during re-examination or a patent trial and appeal board proceeding. So the USPTO is active in this area. But going back to pending legislation, another patent troll behavior is to sue customers of manufacturers rather than a manufacturer that's the source of the allegedly infringing device or process. Under a customer suit, the customer is faced with a patent lawsuit where it has little technical information on hand to immediately defend itself, and so it's under extreme pressure to settle or otherwise resolve the patent case. Section 5 of the House bill is directed to this customer suit conduct and provides for an automatic stay of a customer suit if there's consent between the customer and the manufacturer, if the manufacturer is in another case with the same patent or a patent that's related to the same accused product, and the customer agrees to be bound by common issues in the manufacturer suit. This mandatory stay of a customer suit can be lifted by the court under certain circumstances. The Senate bill also has an automatic customer stay provision. The House bill further provides protections in the area of trademark law. Section 6D would modify the bankruptcy code to provide intellectual property is also a trademark. As a result, it makes clear that U.S. courts will not recognize unilateral cancellation of trademark licenses by a bankrupt licensor or a bankruptcy trustee under the Bankruptcy Code 365N. The Senate bill also has this type of provision. Section 9 of the House bill has a variety of provisions, all directed to technical corrections of the America Invents Act. Section 9A, for example, limits the estoppel for the USPTO post-grant review proceedings so that the estoppel applies only to issues that were actually litigated in the USPTO. Section 9B prevents the USPTO Patent Trial and Appeal Board from using its current patent claim construction rule, that is the broadest reasonable construction, and would require the Patent Trial and Appeal Board to use an ordinary and customary meaning rule in claim construction that is closer to the rule of claim construction that is currently used by the federal court. Section 9B codifies the basis for invalidity in the United States called obviousness type double patenting, so that it's clear that the Patent Trial and Appeal Board in the United States Patent and Trademark Office may invalidate the claims on this basis. The currently pending Senate bill also has these provisions. But there are more in the House bill. And as I noted, this Section 9 of the House bill is directed to correcting the America Invents Act, which was enacted just a few years ago, and it is one of the most sweeping changes to U.S. patent law in over 50 years. So corrections to the America Invents Act, even technical ones, may have substantial impact on a patent owner's portfolio. I've noted just a few of these technical corrections in the House bill, and I invite you to review the firm's website under the Alert section of the site for a more detailed discussion of the House bill, including Section 9, and you can also obtain your own copy of the House bill. Although I've referenced a pending Senate bill today, it's fair to say that it is under much change. There's only been one hearing before the Senate, and that's really the Senate Judiciary Committee on S-1720, and there will likely be more, although the dates of these hearings have yet to be set. A full Senate vote is expected in 2014, and President Obama has expressed a willingness to sign this type of legislation. So it's important to watch for further developments in this area in 2014, because the legislation will affect the ability of all companies and inventors to enforce their valuable patent rights and their ability to defend themselves against assertions of patent infringement. With that, I turn it back to you, Jim.
Great, thanks, Brad. As I listened to my colleagues, I made some notes on some important takeaways from today's presentations. Starting first with Scott's trademark presentation, the covenant not to sue that the Supreme Court affirmed in the Nike Already case seems to me to provide trademark owners with a new opportunity to file a lawsuit to test the waters, and if the water gets too hot, to escape with your trademark rights not subject to an invalidity attack. Also, these new GTLDs, where you can use company names instead of .com or .net, you can use .Brinks Gilson, opens up a whole new horizon of possibilities for use of trademarks, both that a brand owner wants and ones that should concern a brand owner. And this is an area where brand owners need to continue to be vigilant, monitoring new developments in the law to see how they may affect the value and protection of your brands. And then the The Supreme Court, it looks like, may or may not provide some clear guidance on who has standing for asserting false advertising claims, which is an important issue when your company is facing a false advertising situation from a potential competitor. Regarding patent eligibility, it seems like this issue of trying to define a clear boundary line for what constitutes patentable and unpatentable subject matter is one that the Supreme Court has been wrestling with for at least 40 years now. And we still lack a clear, simple explanation of what is and is not patentable subject matter, and that we may continue to live in this zone of uncertainty for some time. It reminds me of Justice Potter Stewart's explanation of the standard for pornography. I know it when I see it. And as long as we continue to have that sort of legal standard, I think it's really important that when inventors and companies are looking to protect their innovations in industries like biotech and software, where you're dealing with esoteric abstract ideas, that you can turn to people like Mark Richards and Amir Penn, who not only are very skilled and knowledgeable patent lawyers, know the law, but also have a very deep grounding and education experience with the relevant scientific fields. Then finally, Brad's told us about some proposed changes that could have significant impacts on patent litigation in the U.S. going forward. It seems like there is a wide consensus that there are some abuses in the system and there's a need for reform. It seems to me the key issue is going to be how to achieve those objectives and not incur some unintended adverse consequences. I'm reminded that it was just a few years ago that Congress approved the American Invents Act, which included some provisions that would reform patent litigation to attempt to remedy some of the perceived abuses by MPEs. And what happened? Well, these MPEs are run by some very intelligent, sharp people, and they created and figured out some ways to design around and avoid the provisions of the American Invents Act. And the result, I think a lot of companies feel that after the American Invents Act, we really don't see a change in the MPE litigation, which is why there's these new legislation proposals before Congress. So what assurance do we have Congress will get it right this time? Well, that's a challenge. We're in an election year, and it's a political process. And I think the bottom line is all patent owners need to pay close attention to this legislation to make sure, one, is it really going to achieve the intended objectives and really curtail some of the perceived abuses, and do that without harming other companies' legitimate intentions to enforce their patents through litigation. Because this intended litigation just isn't directed to MPEs. It's not easy to always put a company in a category that they're an MPE or not an MPE. So even companies that are enforcing litigation, or enforcing their patents in litigation against competitors they believe are infringing their patents, are going to have to deal with these new provisions. So I think the key here is to stay tuned and pay close attention. And if you're concerned, consult with your lawyers, consult with your congressperson and your senator. That concludes our presentation today. Thank you so much for taking time out of your busy schedules to join us. We realize that some of you may have questions. If you do, feel free to contact myself or any of my colleagues who presented here today. You can find our bios and our contact information on our website at www.brinksgilson.com. Again, thank you and have a good day.